Alright, patent laws, chapter 11, application for patent. Application for patent, American Investment Act, application pre-American Investment Act, application specification, pre-American Investment and pre-American Invention Act, specification drawing model specimens, inventor's oath of declaration, pre-American Invention Act, oath of application inventors, pre-American Act, American Inventors Inventor Act, inventors, death, incapacity of the inventor following by other inventor, pre-America Invention Act following by other inventor, benefit of early filing date, right of priority, pre-American Inventors Act, benefit early filing date, rule priority, benefit early filing date of the United States. Pre-120, benefit of early filing date of the United States, divisional application, pre-American Inventive Act, division, application, confidential status, application, publication, patent application, micro-entity, denied. Alright, Title 35 U.S. Standard Code 111, application, in general written application for shall be authorized to made by the inventor, except the otherwise provided with the title and writing of the director. Content such of the application shall include a specification as described in Section 112, a drawing specified in Section 113, an oath and declaration described in 115, fees, oath and declaration claims, application accompanied by the fee required by the law of the fee, oath and declaration, and one or more of the claims submitted with the after filing date of the application with such period with under such conditions, including the payment of surcharge as prescribed by the director upon failure to submit with the oath and declaration one or more claims such as the prescribed period, application shall be regardless as abandoned. Filing date, the filing date, application shall be dated without specification, with or without claims received in the United States Patent Trademark Office. The provisional application authorization provision, application for the patent shall be authorized to be made by the inventor, except the otherwise provided by the title and writing of the director. Such application should include a specification in Section 112A and a drawing specified in 113. Claim required in subsection B through E, Section 112, shall not require provisional application fee. 3. Fee. Application shall be accompanied with the fee required by law. The fee may be submitted in the filing date of the application in such period under such conditions, including payment of surcharge as may be prescribed by the director. Upon failure to submit within such prescribed period, the application regardless is abandoned. 4. Filing date. The filing date of the provision application shall be the date of specification with or without claims received in the United States Patent and Trademark Office. Abandonment notwithstanding the absence of the claim upon timely request prescribed by the director. Provisional application treated by the application filed in subsection A, subsection 119E3. If no such request as provisional application is regarded abandoned 12 months after the filing date, such application shall not subject to revival after a 12-month period. 6. After the other basis for provisional application, such all conditions subsection 119E prescribed by the director and application patent filed under subsection A may be treated with a provisional application for patent. 7. No right, priority, or benefit. Earliest filing date. Provisional application should be not entitled right, priority, any other application under section 119, 365, 386A. And to benefit earlier filing date of the United States in Section 120, 121, 365C, or 386C. Application provision title relating to the application of the patent shall apply with the provision application for the patent, except the otherwise provided, except for the provisional application for the patent should be subject to Section 131 through and 135. Provided filing application, notwithstanding the provision subsection A, but the director prescribed with the conditions including payment of surcharge under the reference made on the filing application under the subsection A, previously filed application specifying previously filed application by application no more number in the intellectual property authority of the country with which the application was filed shall constitute with the specification any of the drawing subsequent application purpose of the filing date, copy of the specification any of the drawing previously filed with the application submitted with such period under such condition may be described by the director. Failure to submit with a copy of the specification any of the drawings of the previously filed application with prescribed period shall be the result of the application has regarded as abandoned. Such the application should be treated with the never filed unless the application revised under subsection 27 of the copy of the specification any of the drawings previously filed application are submitted in the director Alright, 35 U.S. Standard Code 111, the pre-PLT American Inventors Act application, general written application, application for the patent shall be made, authorized made by the inventor, except for the otherwise provided in the title, writing, of the director. Contents shall include a specification prescribed in 1/3/12, showing prescribed in 113, an oath of declaration, section 115, fees and other oath of declaration. The application must be accompanied with a fee required by law. For the fee and oath of the declaration may be submitted after the specification required drawing or submitted within such a period or in such condition, including payment of the surcharge, may be described by the director. Failure to submit, upon failure to submit fee and oath of the declaration which such prescribed the application, regardless of the payment, unless it shown the satisfaction directory of the delay of submitting the fee and oath declaration unavoidable and unintentional. Filling the application shall be dated on which the specification required drawing or receipt of the patent, trademark, off of the provisional application. Authorization provisional application for the patent shall be made, authorized, made by the inventor, except for the otherwise provided in the title and writing of the director. Such application shall include a specification prescribed in section 112A, a drawing specified and prescribed in 113, claim and claim required in subsection B through E to 112 shall be not require provisional application. Fee application must be accompanied with a fee required by law. The fee may be submitted with the specification required drawing submitted within such period, such condition, include payment, surcharge may be prescribed by the director. See, upon failure to submit fees such as prescribed period, application shall be regarded with abandoned unless shown with the satisfaction of the director. Delay submitting the fee was unavoidable or unintentional. For filing date, provisional application shall be dated with the specification of the required drawing received of the patent trademark office. Abandonment and notwithstanding the absence of clearly upon timely request to prescribe of the director, provisional application may be dated with the application filed in subsection A of the subsection 119E. 3. And no such request shall the provision application shall be regarded with the abandoned 12 months of the filing date of such application shall be not subject to the revival after 12-month period. 6. Other basis for the provisional application shall fulfill all the conditions subsection 119E prescribed by the director in an application patent filed in subsection A of the be treated with the provisional application to repatent. 7. No right with the priority benefit of the earliest filing date provisional application to be not entitled to the right or priority of any other application under section 119, 365, or 365A. Benefit of the early filing date of the United States section 120, 121, or 365C. Applicable provisions of the title regarding application patent shall apply with the provisional application for the patent, except the otherwise provided, except for the provisional application for the patent should not be subject to 131 and 135. Title 35 U.S. Standard Code Pre-American Inventors Act application, general written application, application for the patent shall be made or authorized made by the inventor, except for the otherwise provided with the title and writing of the director. Content such as the application shall include specification prescribed in 112 of the titles, drawing specified in prescribed in 113 of the title, and oath. The application prescribed in the section 115 of the title, fee and oath. The application must be accompanied with the fee required. The fee and oath may be submitted with the specification and required drawing, or submitted with such period under such conditions, including the payment of surcharge as may be prescribed by the director. Failure to submit with the fee and oath of the prescribed period. The application shall, regardless of any, unless it's shown with the satisfaction of the director, delaying submitting the fee for the oath for the unavoidable, unintentional filing of the date. Application should be the date of the specification required drawing or receipt of the patent trademark off of the prior authorization application. One authorization provisional application shall be made by the authorized made and by the inventor, except for the otherwise provided within the title writing director. Such application shall include specification prescribed in the first paragraph, section 112. This title of drawing specified in section 113 is titled claim. A claim required in the second and fifth paragraph, section 112 shall not be required in provisional application. Fee application must be accompanied with the fee required by law. The fee may be substituted after the specification required for the drawing submitted within such a period with done in such conditions, including the payment surcharge as may be described by the director. Upon failure to submit the fee such for the prescribed period of the application, such regard for the ban unless it's shown with the satisfaction of the director. Delaying submitting the fee was unavoidable. Unintentional filing date. The filing date provisional application of the date of specification any of the required drawing receipt of the patent trademark off the abandonment and notwithstanding absence of the claim upon timely request prescribed by the director. Provisional application may be treated with the application filed under subsection A subsect to section 119E3 of the title, and so such request for the provisional application shall be regarded as abandoned 12 months after the filing date of the application shall not be subject to revival after 12-month period. 6. Other basis for the provisional application subject to condition subsection 119E. Title prescribed with the directive of the application patent filed under subsection A may be retrieved with the provisional application for the patent. No right with the priority benefit with the earliest filing date of the provisional application should be not entitled to the right party. Any other application under subsection 119.365A title to benefit and earlier filing date under the United States under Section 120, 121, 365C, applicable provision of the title relating to the application for the patent shall apply with the provisional application patent except for the otherwise provided except for the provisional application for patent shall not be subject to Section 115, 131, 135, or 155 of the Title 35 United States Code specification. In general, specification contains written description and invention of the manner of the process of the making and using in full, clear, concise, with the exact terms that enable the person skilled in the art to which the pertains, the which most narrowly connected to the make use the same set forth and in the best mode contemplated by the inventor, joint inventor, in carrying out the invention. Conclusion specification shall conclude one or more claims, particularly with the pointing out the distinctly claiming subject matter of the inventor of the joint inventor, regardless of the invention form. A claim may be written independent over the nature of the case admits of the dependent and multiple of the dependent form. Reference for the dependent and dependent form subject to the subsection E of the claim of the dependent of the forms contained with the reference for the claim previously set forth and then specified with the further limitation subject matter claim in the dependent form shall be construed with an incorporate reference to all limitations of the claim which refers. He reference to the multiple dependent form. The claim multiple dependent form shall contain the reference alternatively only to more than one claim previously set forth specified with the further limitation subject matter claim, and the multi-dependent claim shall not serve the basis of the other multiple dependent claim. Multiple dependent claim construed with incorporated by the reference limitation particular claim in relation to which is being considered. If element in claim combination, an element of the claim combination may be expressed for the main step of the performing specified function without rectile structure material X with support thereof, such of the claims constructed cover the corresponding structure material X described in specification equivalents thereof. Section 135, 112 Pre-American American Inventors Act specification. Specification shall contain with a written description of the invention, manner of the process of making either the skillful, clear, concise, exact terms to enable the person skillful to which it pertains, to which it is most nearly connected to make and use the same style set, the best mode contemplated by the inventor carrying out the invention. Specification shall include one or more of the claims, particularly pointing out with the distinctly claiming the subject matter of the application with regard to the invention claim with a written independent or in the nature of the case admits the dependent and multiple dependent form subject to the following paragraph claim in the dependent form shall contain the reference claim previously set forth and then specified with the further limitations subject matter claim of the claim in the dependent form shall be constructed and incorporated with the reference limitation claims it refers. A claim multiple dependent form should contain the reference alternatively only with more than one precisely set with the fourth that specified the limitation subject matter claim and a multiple dependent claim not serve the basis of any other multiple dependent claim and a multiple dependent claim should contribute and incorporate by the reference of all limitation particular claim and relating to the being considered. An element in the claim for a combination may be expressed with the means or step of the performing specified function without rectile structure of the material or acts or support thereof, such that the claim should be constructed or covered with the corresponding structure of the material act, describing the specification equivalents thereof. Title 35 U.S. Standard Code 113 Drawings. The application furnishing the drawing when necessary for the understanding subject matter so will be patent with the nature of the subject matter admits for the illustration drawing with the application no furnishing besides the drawing. The director may require submission within a time period of not less than 2 months for the sending with the notice thereof of the drawing submitted with the filing date. Application may be not used to overcome insufficiency of the specification due to lack of enable the disclosure and otherwise inadequate disclosure therein, or to supplement original disclosure thereof for the purpose of interpretation scope of the claim. Title 35 U.S. Standard Code 114 Model Specimen. The director required that the application furnish a model of the convenient size exhibiting advantages of several parts of the invention. Inventors relate the composition of matter of the director may require that the application furnish specimens and ingredients for purpose of inspection of the experiment. 1. Title 35 U.S. Standard Code Inventor's Oath of the Declaration. Name of the inventor, Inventor's Oath of the or Declaration, application for the patent filed under Section 111A with the comments for the national strategy under Section 371 shall include the mandate to include the name, inventor, invention claim of the applicant, except otherwise provided with the section. Each individual inventor of the joint inventor claimed invention applicant pay shall execute the oath declaration connection with the application of the required statements An oath of the declaration subsection A shall contain a statement that the application that was made authorized by made of and declarant shall be the individual believed that his or herself to be the original inventor, original joint inventor, or claimed invention in the application. Additional requirements of the director may specify that additional information relating to the inventor of the invention is required to be included in the oath of declaration in subsection A. The substitute statement in general, the lieu of executing over the declaration subsection A by the applicant of the patent may provide with a substitute statement of the circumstances prescribed in the paragraph 2 with additional circumstance, but the director may specify regulation permitted circumstances substitute with the statement on paragraph 1 permitted with respect of any individual who is unable to file over the declaration under subsection A, which becomes the individual. One is deceased under legal incapacity, cannot be found, reach, or diligent after the obligation to assign the invention, refused to the oath and declaration required under subsection A contents. Substitute statement under the subsection shall A. identify the individual with respect to whom the statement applies to B. set forth the circumstance representative of the permanent basis of the filing substitute with the statement in lieu of the oath and declaration subsection A. containing any additional information, including any showing required by the director making records of the statements and assigning that of the record individual who is under the obligation assignment of the application for the patent may include required statements under subsection B and C in the assignment actually by the individual in lieu of filing such statement separately. Time for filing the applicant patent shall provide the required oath and declaration in subsection A, substitute with the statement in subsection D, a record assignment when meeting the requirements of subsection E no later than the date on which the issue fee for the payment is patents paid. G. Earlier filed application containing the required statement and substitute for the statement exemption from the requirements under the section shall not apply for the individual with respect to the application for the patent. The individual is named with the inventor of the inventor, joint inventor for the claim of the benefit under 121, 365C, 386, or 386C for the filing of the earlier filed application. A. The oath of the declaration meeting with the requirement subsection A was executed with the individual filed with the connection with the earlier filed application. B. Substitute with the statement the meeting of the requirement subsection D with the file with the connection with the early file with the application with respect to the individual. Or C. With the assignment the meeting of the requirements of the subsection E was executed with the respect to the early filing of the application by the individual who was recorded with the connection with the early filed application. 2. With the copies of the oaths of the declaration statement of the assignments. Nothing over the paragraph 1 may record with a copy of the executed over the declaration, substitute with the statement over the assignment of file with the connection earlier filed with the application include, but a later filed application, supplemental corrected statement of filing additional statements. In general, the person may make a statement that requires the section withdrawal replace the otherwise correct with the statement at any time when the change with the made with the making and naming. Inventor required with the filing of the one or more additional statement in under section of the director shall establish regulation on which such additional statement that may be filed. Supplemental statement not required with the individual execute with the declaration requirements of subsection A or assignment of the meeting the requirements of subsection E with respect to the application plan with the director may not, but therefore require with the make it additional over the declaration of the statement the equivalent to those required by the section connection with the application for the patent and patent issuing thereon. 3. Saving clause of the patent shall not be invalid with unenforceable based on the failure to comply with the requirement under this section. Failure is remedied to provide in paragraph 1. 1. Acknowledgement of penalties. Any declaration statement of file for the pursuant section containing the acknowledgement with a willful false statement made with the declaration statement punishable in section 1001, title 18 by fine, imprisonment no more than 5 years or both. Title 35 U.S. Standard Code 115 Oath of the application. Application shall make an oath that believes himself with the original of the first inventor of the process, machine, manufacture, composition of matter, improvement thereof, of which of the solace of the patent shall state with which country he is a citizen. Such oath may be made before a person in the United States authorized by law with the administrator of the oath when made in the foreign country before a diplomatic consular officer of the United States with the authorized administrator of the oath before any officer having official seal of the authorized administrator of the foreign country in which the application may be deemed with the authority approved with the certificate of diplomatic consular officer of the United States with the apostolate of the official designated foreign country with the treaty with the convention accord with the like effect of the apostles designated official officers of the United States with the trust of the oath is valid with the complies with the laws of the state and the country where made when the application is made with the provide with the title of person other than the inventor of the oath may be varied and informed that it can be made by him for purpose of the section of the consular officer shall include any of the United States serving overseas with the authorized to perform notarial function pursuant to section 1715 revised statutes as amended in title 22 U.S. Standard Code 4221. Title 35 U.S. Standard Code 116, inventors, joint inventions. Inventions made by the two or more persons jointly, if they shall apply with jointly, each for the required oath, except the otherwise provided with the title, with the inventors may apply with the patent joint evenly through one, if they do not physically work together at the same time, each did not make the same type of amount of the contribution, or three, did not make contribution to the subject matter of every claim of the patent. Omitted inventor. If the joint inventor refused the joint application from the patent that cannot be found reached for the diligent after the application may be made with the other inventor on behalf of himself, the omitted inventor. The director on the proof of the pertinent fact after such for the notice of the omitted inventor prescribed that may grant a patent to the inventor making application subject to the same rights whether the omitted inventor would have he had been joined. If the other omitted inventor subsequent joined an application correction for the errors in application whenever through the error of the person's name of the application of the patent of the inventor, or through the error of the inventor is not made with the application, the director makes permanent application amended according under the terms as prescribed. Title 35 U.S. Standard Code 116 Pre-America Inventors Act. Inventors. When an invention was made with the two or more persons jointly, they scale apply with the patent jointly to each for the required oath except the otherwise provided with the title. Inventors may apply with the full patent jointly, even though 1, they did not work together at the same time. 2, they did not make the same type of amount of contribution. 3, each did not make a contribution subject matter every claim of the patent. If a joint inventor refuses the joint application of the patent that cannot be found with the breach of the after the diligent effort of the application may be made by the other inventor by half of himself within the omitted inventor of the director of the proof of the protect in fact with the after shift notice of the omitted inventor for the prescribed of the make grant of the patent to the inventor making the application subject to the same rights of the omitted inventor of the would have then joined with the omitted inventor may be subsequent joined with the application whatever though error person is named in the application for the patent inventor with the error of the inventor is not named in the application such error arose without any of the deceptive intention on his part. Director may permit the application to be amended accordingly under such terms as prescribed. Title 35 U.S. Standard Code 117 Death of the incapacity of the inventor. Legal representative of the deceased inventors of those under the legal incapacity to make the application of the patent upon complying with the requirements on the same terms of the conditions applicable to the inventor. Title 35 118 following by other inventor. Person who the inventor has been assigned at words under the application to assign the invention may make the application for the patent of the person who otherwise sufficient proprietary interest of the matter may make the application for the patent on the behalf of as such an agent for the inventor and proof of the pertinent fact for showing that such action appropriate to preserve the rights for the party of the director grants the patent on the application falling under section person other than the inventor. Patent shall be granted with a real party interest upon such notice the inventor of the director considered to be sufficient. Title 35 U.S. Standard Code 18118 Pre-America Inventors Act falling other than the inventor. When an inventor refuses to execute the application for the patent that can't be found reached for the diligent effort of the person when the inventor has been assigned agreed in writing to assign the invention with the otherwise sufficient with the priority interest of the matter justifying such action making application patent on behalf of the agent with the inventor of the proof of the pertinent fact for showing that such action is necessary to prescribe such action is necessary to preserve the rights of the party for the prevent irreparable damage of the director may grant a patent such inventor upon with the notice of him as the director deems sufficient to the compliance with such regulation as prescribed. Title 35 U.S. Standard Code 119 benefit the early filing date with the right of priority application of the patent with the invention filed for the country of any with the person who had with the legal with the representative of the design with the previously regularly filed with the application for the patent with the same invention with the foreign country which affords similar privilege of the case application filed with the United States with the civil union with the United States with the WTO member of the country shall have the same effect that the same application would have filed with the country on the date of the application for the patent for the same invention filed with the foreign country application of the country filed with the 12 months for the earlier of the date with such foreign application was filed with the director prescribed with the regulation including with the requirement of the payment and the fee specified 41A's of them pursuant with the 12-month period set forth with the subsection may examine the additional 2 months of that for the delay in the filing application in the country a 12-month period with the unintentional. No application for the patent should be themselves with the right of priority claim with the patent with the trademark office identified with the foreign application specifying the application with the number of the foreign application for the intellectual property authority or the country in or for which application was filed with the end of the date of the filing application at the same time during pendency receipt of the application required by the director. The director shall consider failure of the application timely claim of the priority waiver that such claim of the director shall proceed with, including the requirement of payment of fees specified within Section 41A, except the unintentionally delayed claim under Section. The director may require the certified copy of the original foreign application specification drawings upon which has paid for the translation, and if not, the English language shall for the information the director consider necessary. Any certification shall be made by foreign intellectual property authority in which foreign application was filed within show with the date of the application filing with the specification of the other papers. In like manner, subject to the same condition requirements, the right provided with the section based with the subsequent regularly filed with the application of the same foreign country instead of the filed foreign application provided with any foreign application filed prior to the subsequent application has been withdrawn, demanded, otherwise disposed of without having laid open to the public inspection without leaving the right out of standing, and has not served the now nor therefore shall serve the basis for the claiming of the right of priority. Application for the inventor certificate of the foreign country for the application of the right to apply with the discretion each for even the patent of the inventor certificate shall be treated within the country of the same manner, having the same effect for the purpose of the right of the properties in section require application patent is subject to the same condition requirement section apply with the application patents provided the application entitled with the benefit Stockholm revision of the Paris Convention at the time of such filing, and an application for the file within section 111A section or section 363 mentions disclosed in this manner provided in section 112A with the other requirement to disclose the best mode of the provisional application filed under section 111B by the inventor and inventor's name with the provisional application have the same effect such an invention filed with the date of the original application filed under section 111B. Application of patent filed within section 111A with the section 363 filed within no later than 12 months of the date of the provisional with the application filed with the contained with the amended with the contained specified requirements for the provisional application for the director of the may prescribe the regulation include the requirement of payment of fees specified in 41A for the pursuit of the 12-month period set forth with the discretion may be extended additional 2 months delaying the filing application of 111A or section 363 within the 12-month period with an unintentional with no application shall be entitled for the benefits early filed with the provisional application or in subsection left the amendment contained with the specific reference early filed with the provisional application submitted at the time during dependency of the application as required by the director. The director may consider the failure to submit the amendment with the timely period with the waiver of any of the benefit of subsection. The director may be established proceed with including payment of the fee specified in section 141A7 to accept an intentional delay submission of the amendment under this section. A provisional application filed under section 111 of the that may not be relied upon with the receipt of the payment and trademark office unless the fee is set forth in the subparagraph A or C with the section 41A1 have been paid if the day of the 12 months filing date of the provisional application falls on Saturday, Sunday, or federal holiday of the district Columbia. The period of pendency for the provisional application shall extend the next seating secular business day with the application patent filed under subsection 36.3 receiving officer other than the patent trademark office the 12 month additional 2 month period set forth with the subsection shall be extended as provided with the treaty with the regulation defined in the section application for the plant breach of the rights of the WTO of the member of the country with the foreign UPOV with the contracting party shall may have the same effect for the purpose of the right priority for the subsection A through C of the section application of the patent subject to the same conditional requirements of the section shall apply with the patents for patents. G, as reviewed in the section of the term WT member means the same as the terms described in section 104B2, but then the term UPO of the contracting party means the member international convention of protection of the new varieties of plants. Title 35 U.S. Standard Code 119 Pre-America Invention Act Benefit or Early Filing Date Right of Priority. Application over the patent of the invention for all of the country with the person who has the legal representative at the time of the previously legally filed with the application for the patent for the same invention of the foreign country but for the same privileges within the case of the application for the United States with the citizen of the United States or on a WTO member of the country shall have the same effect of the same application when have filed with the country on the date on which the application with the patent and the same invention was first filed with the foreign country for the application with the country filed for the 12-month period of the earliest date of the foreign application was filed, but no patent granted by any application with the patent of the invention of the patent and described with the patent regular publication within any country more than 1 year before the day of the actual filing application with the country, which have public use and sale of the country made for the 1 year of such filing. Title 35 U.S. Standard Code 120 Benefit Early Filing Date in the United States. Application with the for patent invitation to discover the manner in section 112A with the other requirement to discover the best mode. In an application previously filed with the United States provided with the section 363 or 385, which of the name of the inventor joint inventor with the previously filed with the application have the same effect with the trust mentioned in that file with the date with the prior application filed before the patent abandonment determination preceding the first application similarly entitled to the benefit of the filing date of the first application if the contains or is amended with the containment of specific reference for the early file of the application. No application is filed for the benefit of the early file of the application under this section left the amendment contains specific reference for the earlier filed application submitted with during the pendency of the application director required by the director. Director may be considered the failure to submit the amendment with the time period of the waiver of the benefit. Any benefit under this section, the director may establish for the procedure, including requirement of the payment of the fees specified in section 41A7 to accept or intentionally delay submission of the amendment under this section. Title 35 U.S. Standard Code 120 Pre-America Invention Act benefit the early filing date in the United States. An application of the patent with the invention discover the manner of the described provided in section 112A with the other requirement to discover the best mode of the application previously filed with the United States provided in section 363 with the file with the inventor and name of the previously filed with the application same in effect with the invention through the file with the date of the prior application filed with the floor of the patent abandonment with the determination received with the first application or with the application similarly in terms of the benefit of the filing date of the first application if the contained with the intended with the contained specific reference of the earlier filed application. No application shall be entitled to the benefit earlier filed with the application under section 11 of the amendment containing a specific reference for the earlier file of the application submitted with such time during pendency of the application as required by the director. The director may consider the failure to submit the amendment within the time period of waiver any benefit under the subsection. The director may establish procedure including payment of the surcharge to unintentional delayed submission of the amendment under this section. Title 35 U.S. Standard Code 121, a divisional application, and two more independent distinction connections, invention with the claim of the one application for the director may require the application restricted to one of the invention for the other invention is made the subject of the divisional application complies requirement section 120. Who shall be entitled for the benefit of filing with the original application of the patent issued for the application for the requirement of the restriction and over the section has been made or when the application filed with the result of the requirement shall not be due for the reference either the patent trademark off of the courts against the original application again for the original application for the patent issued for either of them. Original application is filed before the issuance of the patent. The other application validity of the patent shall be not question failure for the director to require the application to be restricted to one invention. Title 35 U.S. Standard Code 121 Pre-America Invention Act Divisional Application. The two more independent district inventions claim of the one application for the director may require the application restricted to one invention. Other inventions may subject to the divisional application which comply with the requirements section 120 of the title shall be entitled for the benefit of the filing date of the original application for the patent issuing the application with respect to the requirement for the restriction under this section has been made when the application filed with the result of the requirement shall not be with the reference either with the patent trademark of the courts or grant the divisional application against for the original application any patent issued for the year either on them or the divisional application filed with the issue of the patents for the other application for the divisional application directly sold with the subject matter described claim. Original application is filed with the director may dispense with the signing of the execution of the inventory validity of the patent should not be question failure for the director that require the application to be restricted to one invention. Title 35 U.S. Standard Code 122 Confidential Status Application Publication Patent Application Confidential except for the provided in subsection B. The application of the patents should be kept confidential of the patent trademark off the domain information concerning the same given and written without authority of the application unless other than necessary to carry out the provisions of the Act of the Congress. Such special circumstance may be determined by the publication in general of the subject. It's paragraph 2 of the H application patent published within accordance with the procedure determined by the director promptly after the expiration period of 18 months earliest following the date of the benefit itself at the end of the title of the request of the application published earlier and the end of the 12-month period. No information concerning the published patent application should be made available to the public except if the director determines, notwithstanding the other provisions of law, the determination director will leave not to release information concerning published patent application shall be filed and non-reviewable except the exemptions, and application shall not be published if the application is no longer pending subject to secrecy order section 181. Provisional application filed in 111B. The application design patent filed under chapter 16. B1. If the application maker of the request upon certifying that the invention is covered the application that will not suffer the application filed with another country with a multi-letter international agreement to require the publication application 8-12 months after the filing of the application not published with the provided in paragraph 1. 2. For the application of the may resign with the request made under clause at any time with the application of the made with the request under the clause subsequent to the file with a foreign country within a multilateral international agreement specified in class 1 with the application of the direct for the invention this clause with the application file with the patent trademark office shall be notified with the director shall following no later than 45 days after the filing with the foreign international application. The failure to application provides such notice with the prescribed period with the result of the application regardless of the advantage. If the application requires signs or request of the made under clause 1 with the notified with the director for the application of the filing with the foreign country multilateral international agreement specified in clause 1 application shall be published in accordance with the provision in paragraph 1 and assume with the practical effect of the after the date specified in clause 1. 5. The applicant will then file with the application more than the foreign country for the directly through the multilateral international agreements as foreign file with the application corresponding with the application file with the patent and trademark office or descriptive invention except for the foreign and file with the application is less extent with the application the descriptive invention the application file with the post trademark patent trademark office with the application submitted with the redicated copy of the application from the patent trademark office eliminating with the part with the description and invention such for the application that also contain any of the corresponding application file with the foreign country the director or other may only publish the redicated copy of the application with the redicated copy of the application not received within 16 months after the earliest effective of the filing date of the which of the benefits of the title of the provisions of section 154D with the shall not apply with the claim with the description of the invention published with the redicated application file within this clause. Respect with the claim does not enable the persons to go with the art to make sure of the subject matter of the claim. Protests and pre-issuance opposition. The director shall establish appropriate procedure to ensure that no protest of the other form of the pre-issuance of the opposition to the grant of the patent of the application may be initiated after publication application without express written consent of the application. National security no application for the patient shall be published under subsection B1 of the publication disclosure invention of the detrimental national security. The director shall establish a permanent procedure should application properly identified with the secrecy of such inventions submitted in accordance with chapter 17 pre-issuance submission with a third party. General third party may submit with the considerization include with the record of patent application and published patent application the printed with the publication and published relevance examination application submission made writing before earlier with the day of the night notice for the allowance under subsection 151 mailed with the applicant with the patent later 6 months after the date of the applicant patent is first published under section 122 by the office at the date of the first projection under section 132 with the claim of the examiner during examination of the application of the patent and other requirements any submission under paragraph 1 set forth with a concise description with asserted relevance for each submitted document be accompanied by such a fee the director may prescribe and see include a statement of the person makes such submission affirming the submission was made in compliance with this section. Alright, Title 35 U.S. Standard Code 123, microentity identified, microentity defined. General for the purpose of the title of the term microentity means the application that makes a certification of that application with a qualified small entity with a defined regulation issued with the director has not by the name of the inventor more than 4 previously filed application with the application filed with another country provisional application or in section 1 from 11B international application filed under and treaty defined in section 351A with the basic national fee under section 41A was not paid. Did not the calendar year preceding the calendar for the applicable the fee is being paid for the gross income of the defined section 61 Internal Revenue Code in 1986 exceeding 3 times the median household income for the preceding calendar year, most recently reported by the Bureau of Census. It is not a sum of the grain, but the conveyed is not obvious for the under application of the contract law with the sign with the grant with the conveyed, the license with the other owner, interest, the application for the conveyed, and with the calendar year proceed with the calendar year with the applicable fee for the being paid, have the gross income defined in section 61A of the Internal Revenue Code in 1986 to see the 3 times of the median household income of the preceding calendar year, most recently reported for the Bureau of Congress. Application of the result of the prior employment of the application for the next over the name of the previously filed with the application with the purpose of section 18 of the application as a file with the owner is under obligated for the contract law that to assign all ownership of the application for the result of the applicant's previous employment. Foreign currency exchange rate if the application with any of the gross income of the preceding calendar year with the not in U.S. dollar with the average currency exchange rate that is reported with the internal revenue for the during the calendar year should be used to determine whether the applicant's any gross income exceeds the threshold specified in paragraph 3 and 4. Subsection A. D. Institutes of higher education for purpose of the microentity shall include with the application certifying with the application to employ with the applicant with the obtainment of the majority applicant income of the institute with the higher entity defined in section 101A of the Higher Education Act 1965 or the applicant has assigned the grant conveyed with under obligation of the contract or law with the assignment of the grant conveyed for the license or ownership of the interest of the particular application such institute with the higher education. Directors of the authority additional limited to impose with the director of the May with the director of the discretion impose with the income limited to the annual filing limits over the limits of the May qualify with the micro and the pursuant of this action. The director determined the size of the additional limited to the reasonable and asked to avoid undue impact on their patent applicants for the owner of the other way and the rest of what reasonably necessary appropriate at least 3 months before the limit is proposed in prose. Who is pursuant with the subsection taking effect with the director of the shall inform the committee of the Judiciary House of the representative of the committee of the Judiciary Senate and such proposed limits have penalty for false certification additional to any other penalty available under the law with the trial of the false made with the certification by the director of the amount shall be not less than 3 times the amount with any fail to pay as a result of the false certification. Whether the director discovers the false certification before or after the date of the patent has been issued. Chapter 12, Examining of applications.